Hi, in this video I wanted to give you an update on EU law and really give you a review of the last 12 months because we're coming to the end of 2014 and what developments there have been in EU case law. I'm just going to give you the headlines of some recent case law that may be of interest to you. The first one, I want to go back to some cases that were from the 16th of January this year from the Court of Justice, and the first one is Reyes. Now in Reyes it looked at over 21 direct descendants, and it confirmed that dependency in EU law is a question of fact rather than a question of necessity. So the fact that a dependent over 21 child in this case was well placed to obtain employment and intended to do so did not undermine the fact that they were a dependent in that case. So remember, when you're looking at dependency in EU law, it's a question of fact. Another judgment from the 16th of January, and I'll probably mispronounce this, was Onuwakeri. This was looking at periods of imprisonment and a permanent right of residence. Now, periods of imprisonment do break the continuity of residence for a permanent right of residence. On the same day, the Court of Justice also gave judgment in the case of MG, and that's been followed up by an upper tribunal case, which is MG 2014 UK UT 392 on the 12th of August this year. So look at the two MG cases. And this looks at imprisonment and 10 years residence, which entitles you to the highest level of protection and the imperative grounds. Now it says you have to count back the 10 years from the date of the decision, and imprisonment is capable of breaking that period of residence, but it doesn't necessarily do so. So there's a tension in the judgment. And the key question you've got to look at is that of integration. So prison is capable of breaking 10 years residence and the higher level of protection, but it may not do so on the facts. Another big issue in EU law over the last year has been proxy marriages. So you've got an EU citizen residing in the UK who will marry a third country national who's perhaps an overstayer here, and they'll marry by proxy marriage because proxy marriage is permitted in the country of the third country national. And there's been two upper tribunal cases looking at this. The first one is Kareem, proxy marriages EU law, 2014 UK UT 24. That's also from the 16th of January. 16th of January was a busy day. And then TA and others, Kareem explained, 2014 UK UT 316 from the 18th of June 2014. Kareem was a difficult judgment, and it's led to sort of some controversy. So the TA and others follows up Kareem, saying as a matter of EU law, marriages must always be examined in accordance to the laws of the member state of the EU national. Now, I think these judgments are problematic and it needs challenging and perhaps taking to the Court of Justice. But if you've got a case involving a proxy marriage, please look at Kareem, look at TA. Just moving on now, another case was a case called Diakate from the 13th of January 2014 from the Court of Justice, and that clarified Article 15C of the directive and what is an internal armed conflict. And the court said we don't have to look at matters of international humanitarian law or look at intensity and duration of conflict, but if a state's armed forces are in conflict with another armed group, or two or more armed groups are in conflict with each other, a state of internal armed conflict exists. So that clarified the law in respect of humanitarian protection. There's also been some developments in the year in the Surinder Singh route. As you'll know, the government amended the EEA regulations to include a centre of life test. Well, in a judgment called O&B from the 12th of March 2014 from the Court of Justice, they simplified the Surinder Singh approach and they in fact said it's not just concerned about workers and the self-employed, and it applies more generally. And if somebody has moved to a member state and there's been residence for 3 months and during that time they've created or strengthened family life, they can benefit from the Surinder Singh route. Temporary residence, just going on weekends is not enough, they confirmed in that case. And the court were acutely aware of abuse of rights, so they're going to look at a period of genuine residence in the host member state. But As of now, and that judgment in O and B, the EEA regulations are out of step with the Court of Justice ruling, and the UK government are going to have to amend the regulations. And in fact, the Commission have taken enforcement proceedings against the UK government. And there's some documents circulating from the Commission which say the Commission thinks that EEA regulations are not reflective of EU law. So if you're doing a Surinder Singh case, I'd encourage you to look at the O and B judgment from the Court of Justice. The final case I want to look at in this roundup is the case of Sanpree. We waited a long time for Sanpree, and that judgment was given on the 19th of June 2014. And that confirmed that a woman who gave up employment or temporary broker employment for maternity leave was still a worker in terms of EU law, as long as it's for a reasonable period. And I suppose in the UK, when we have maternity periods of about 12 months, a period of 12 months should be reasonable and should not break her status as a worker. So if you've got somebody who's been on maternity leave, or there's perhaps gaps of maternity leave if you're trying to establish a permanent right of residence, look at the case of Sanpree. So that's just a quick roundup of some recent European cases that have happened over 2014, which I'd encourage you to read in this sort of quite tricky area of law. Thanks.